Again, my lords, the request for upgradation, my lords. I just indicate one thing, my lords.
Give it. I shall
Only
see
a
it in the
short
chamber.
issue, my lord. What I'm just praying is a limited remand because the order is a non-speaking one. So it will not take more than 5-10 minutes, my lords. I'm just praying a limited remand, my lords.
Which year?
I have filed in September 2025, my lords.
দেখে নিন ওটা দেখিয়ে নেবেন একবার আপগ্রেডেশনে দিয়ে দেবেন আজকে দেখিয়ে নেবেন ছোট মামলা হলে দিয়ে দেবেন
Much of
My lord, may I be permitted to mention on hearing,
হিয়ারিং which year
2021.
21 কি জি
My lord, may I present to registration cancellation, non-filing of return.
Give it.
Similar
Give it.
prayer, this cancellation of registration, the 2024 matter never appeared.
ওটা দিয়ে দিন দিদি ওই ক্যান্সেলেশন গুলো লিস্টে দিয়ে দেবেন মানে আর্জেন্ট হিয়ারিং এ দিয়ে দেবেন আর্জেন্ট মোশনে দিয়ে দেবেন
Your Lordship, may I mention one matter, Lordship? My item matter is running in the daily list as item number 288. I'm praying for upgradation
Why?
as because there is
I have said you please give your slips I shall see it if it is
Okay.
required I'll upgrade otherwise I may not also
Your Lordship, item number 1. It is a typo correction of the order. There is a typographical error at paragraph number 6, Your Lordship. Can 1 of 2016, it will be 2026, Your Lordship.
লিখেন
And one more, Your Lordship, the
My lord, in item number 2, I beg to appear virtually, my lord. The year, my lord, it would be my lord 25.
লিখে নিন এটা
And my lord, it may be listed in the hearing list, my lord. My lord, I'm praying to add in hearing list, my lord.
It will be Jolu Sheikh and others first state of West Bengal. But typically mistake, my lord. Ramakrishna.
Where is your other side? Where is your other side?
No notice, my lord.
Give notice to them. It will appear as to be mentioned again. Serve notice to them because the name has been wrongly mentioned. Very popular.
It will
Give notice to the other side.
yes, my-
Yes.
next Monday.
Monday রেখে দিই কোনো অর্ডার পাস করছি না মানডে লিখে নিন none appears.
Milord,
You are appearing for
I am for the state milord.
But I beg to appear, Lordship.
I am appearing on behalf of respondent number 9.
On the earlier occasion, was an order, Lordship. BLRO Kulpi,
you are appearing for
petitioner, Lordship.
yes
I am appearing on behalf of respondent number 9.
yes
But I served the order.
who is appearing for the state respondents
There was a direction upon the BLRO to file a report.
yes
Lordship.
state should represent the BLRO I mean somebody should represent the BLRO learned advocate appearing for the state would represent BLRO who is appearing for the state do you have any idea you Serve the office of the learned government pleader. This service will not help. You should serve the office of the
Lordship.
government pleader. লিখে নিন একটা order. Learned advocate appearing for the না PS for the state যেটা লেখা আছে
SPL 2024 না?
My lord, my senior is appearing virtually.
I'm constrained to appear today, Malad. I'm not feeling well from the morning. So, Malad, this is Malad the matter. Matter is appearing in Lordship's Malad the hearing list already, Malad. So, Malad, maybe extended, Malad, for a limited period. In the meantime, your Lordship will take up
But
the
it is
hearing.
till the end of February. What it will be extended? It is till the end of February. Why was it mentioned?
So, Malad,
The
kindly,
end of February, we are just beginning February. We have not even reached halfway mark.
so Malad, kindly, Malad, fix the matter, Malad. If your Lordship, Malad,
There is no requirement of, if I pass an order unnecessarily, why did you mention it? You shouldn't have mentioned it for extension of interim order. Why?
Malad, kindly fix the matter on Malad 27 or 28.
Not now, not today. Extension is দরকারই নেই. Next. Interim order is still 15th February. How can I extend it today? On what basis?
Yes,
The order
yes,
has
Malad.
not.
That I have already told them, Malad. That should not happen.
Yes, next.
But I appear for the petitioner, my lord, led by Mr. Kishore Dotto in this matter, my lord. Last occasion, Mr. Dotto has almost completed his submissions, my lord. Today, he was supposed to close his arguments, my lord. If my lord kindly fixes matter at 12:30, my lord, he is on his legs at court number 16 before the honorable division bench.
Well, 30
Only
will
for
be
the
difficult.
closing statement, my lord.
Time will be difficult because I don't know how I'll be proceeding.
Well, today we will close our submissions. Thereafter, my learned friend can proceed with the
That is
submission.
right, but there are other matters also. That is why it was kept at the top, because
True, my lord.
you wanted it to be at the top. I said it will be taken up within 11,
I
and it
understand,
is
my lord.
taken up within 11.
If that be so, my lord, then we have almost done with our submissions, my lord. If they want to start with the submissions, my lord, we will take note.
No,
Thereafter,
for
the
yet to conclude, how will I, in the meantime, he will start, then he will again come and join. That is not how it can be done.
but humble request, my lord, 5 minutes he will take. Thereafter, the
Very
argument
well, but for 5 minutes, if I am in the midst of the matter, fixing it at 12:30 will.
at 1, my lord, at 1, my lord, for the last 15 minutes, my lord. Kindly, my lord.
Let us see, I don't know which matter, if some matter continues, what will I do? By
I
fixing it
understand.
at 1, I will stop the matter in between.
No, I understand, my
Then-
lord. Then let the matter be passed over for few times,
I'm
my lord.
passing it over. If
Yes.
you come and there is no other matter in the midway, then I'll take it.
Very well, my lord.
All the parties should be there. But
Very well, my lord.
chalo, next. लिखे नहीं, none appears for the petition.
Well, I am put the petition amendment. I serve the notice matters for mentioning upon the state as well as the private respondent.
लिखे नहीं.
I've got statement.
Last occasion, you were not there, now he is not there.
I was suffering from fever for that reason I couldn't attend. Mother, I just submit the report. Please take it on record. Gladly take it on.
Report shows that there is encroachment on government land.
Question number 1.
I'm passing it over. Let's see if the petitioner comes. You keep the report with you. ধরুন কাস্টমার গুলো কল করবেন তখন কল করবেন. Yes. Next.
I'm praying for not today only.
Not today.
Lordship, take this matter after 10 days, Lordship. Kindly respond number 10 and 11 appear on Advocate Dwi Dotto Chakraborty. Unfortunately, her mother-in-law expired, Lordship. Kindly
লিখে নিন.
10 days.
No, no.
Kindly 10 days accommodation, Lordship.
কদিন?
10
days. মারামার টার্ম
Not 851. 851 what I have done.
Please to adjourn your lordship, please to adjourn this matter.
I don't remember. I must have adjourned. I have not dismissed or passed any order as yet. So next. কল করুন, ম্যাটারটা কলই তো করেন.
The Lordship, I appear on behalf of the petitioner. Pursuant to the last order of your Lordship, the state had been directed to produce a copy of the notification for appointment of the SDM Bidhannagar as in place instead of the collector. The state was to produce the notification today.
I'm not appearing for the state, but in any case, not I have checked up. What is fallen from your lordship is absolutely correct. I have a notification which says that the North 24 Parganas, South 24 Parganas, Howrah, Nadia come under the Presidency Division of Calcutta. So, what it will go to? Your lordship is absolutely
Entirety of it then goes.
absolutely, the entire appeal will go. So, what I suggest, I have a responsibility to court. The statute specifically provides that they have 15 days to prefer an appeal. On the ground of Article 14, your lordship will extend that time for let them file a fresh appeal for 15 days. The entire appeal is gone. The proceedings now before the SDM is gone because this is pursuant to the
Yes.
DM's order. So that is also gone. So
Where is the petitioner? Where is Mr. Bhattacharya? Where is he?
Your Lordship, Mr. Bhattacharya is stuck in another court. If you could kindly be grateful enough to grant a short passover.
Because
no, your lordship,
I'll
when
require-
your lordship, keep it at 2 o'clock.
2
Or
o'clock, your
tomorrow.
Lordship has another matter to do.
2 o'clock I have a different.
Then could you lordship keep it at tomorrow? That's not a problem. But the Passover, then I go come. It's because of the answer.
Mr. Bhattacharya, I think appearing virtually.
Hey, okay. They won't calculate. Virtually, but the one go calculate.
I am for the petitioner, kindly, I really, question number 11, kindly takes it up at 12:30, 1 o'clock, 12 o'clock, anytime convenient, I shall try to.
We'll have it on next Thursday then.
The whole thing gets delayed. That is the only thing. Because and let me be very frank. I'm interested in recovery of the possession. So that's why I think your lordship can accommodate on 12:30. I go bound on what he has only said. 12:30, your lordship keeps it.
12:30 will be difficult because Mr. Banerjee, I don't know which matter will continue which way. If it something continues.
Because today, if it is not taken up, it is next Thursday again.
Next Thursday.
That is the problem. I am now the whole thing.
May I most humbly try my luck at 12:30, Millard?
12:30, Mr. Bhattacharya, it will be difficult to fix the time. I don't know how I'll be placed, which matter will take what turn. I don't know because I'll be.
No, let me take my chance, Millard. Let me kindly pass it over for the little bit, Millard. I'm really, Millard, I can't, Millard, explain the situation to your lordship.
Passover leaves us 90 minutes. We are quite far away.
Next week, your lordship, we need to go through this notification and can.
There is nothing in that notification essentially, my lord. Because point is before what your lordship had said. But I have considered because there's an and which separates both.
Yes.
I have no
So
picture.
it absolutely fits into that.
Absolutely, because and the next one comes is specifically appointed by the government. So what your lordship said, I cannot give it. I have a duty to court. I will not say. That's why. We sat down together. We every event.
Kindly pass it over for some time, Millard. I am trying to reach.
Just for a while. If you are not there, I won't take.
No. Your lordship tell me. But then it should be your lordship has a number of matters.
It is 11 o'clock now, Millard. If I can most humbly request.
Any time if all parties are here, I'll take up.
Very good. I'm grateful to you.
The problem is when we come running from there. Because if you lordship says 12:30 or 1 o'clock, I think this will be over 15 minutes.
Millard, may it be taken up at 12 o'clock.
1 o'clock. 1 o'clock, your lordship.
Mr. Banerjee, all of you talk amongst yourself, come together. Whenever
Very
you
well.
are here in the court is
Rajiv, please talk to Mr. Banerjee 1 o'clock.
Time will be difficult.
So you are the busy one. You should be the one to keep the time.
I'm grateful to you, Raj.
8:54, 8:55 both. Yes.
Not
8:56, 8:55, 8:56. All of you can, if all of you are available, I'll take it.
Great. Very kindly.
Milord, I appear for the petitioner, Milord. Is that matter, Milord, whereby a land in front of my land, a government land, has been illegally filled up by the private respondent, Milord. Pursuant to your lordship's direction, Milord, a spot inquiry has been conducted. My learned friend is there, Milord. He has found that it is the land of the government only. So I pray for demolition of the.
Sub-regional officer calls the inquiry to the BLRO, concerned BLRO office, and also the concerned.
What has he found? Unauthorized occupation? Government land. Land is government land.
Land is government land and illegal structures.
I'll direct him to take appropriate steps in accordance with the provisions of the.
The DM may be directed, because under the Bengal Public Demands, Bengal Public Premises Act, the DM is the authority. Yes, very well. SD or DM, whoever may be directed, the
Whoever
illegal
is-
construction may be demolished and the possession may be restored. my lord.
they'll take steps. লিখুন this repetition.
I think to interrupt. Only the hospital, Gram Panchayat, it is also mentioned in my report, in the Gram Panchayat, my learned friend mistakenly,
Baniara Gampon.
there is no such Gram Panchayat.
I'm not going to enter into it. All that I will not enter. লিখুন this repetition Yes. They were there last occasion. None appears for the petitioner. Thank you.
Lordship, I pray for short passing.
My lord, I for the
Lordship, I pray for short passing.
Pass over. Pass. Yes.
For the private platform. Here, me not. Take it. There was the direction of your lordship to come up with the report. A preliminary point has been raised here.
कोई same order लिखे थे. None appears for the petitioner. None appears for the petitioner. For ends of justice, let the matter stand adjourned for the day. Huh? Next.
Lordship, 861, I am for the municipality, Lordship.
Give your name. Give your name. Yes.
Lordship.
It has been only adjourned.
Wait for your lordship. Milord, I am appearing on behalf of the petition in this matter. Lordship, instead of going into details of the case, Lord, I am drawing your lordship's attention to the order dated 29th of January. The last
Yes, Mr. Jena.
29th of Jan.
You have the documents.
Milord, in paragraph 4, Milord, your lordship asked him to, Milord, in support of the submission that the goods lying at the subject premises have
Has been sold.
observed. That report.
Before I hand over the document, Madam,
And a copy of that will be given to me.
First of all, the order matter relating to an appeal. Section 9 under the PPA, Madam. Appeal was preferred. Appeal was dismissed. So long. We filed a section 5 application. And the section 5 application for restoration of the appeal. That appeal was dismissed. In that appeal, there is a rejection in the miscase, I mean restoration application to file a report stating what is the status. I have disclosed everything. What is the status? Section
In that,
yes, that report has added to the writ petition. In spite of that, your lordship directed me to
because that was not pointed out. You could have pointed that out.
Yes, my lord, I have
that day.
seen from the regular judge.
You could have pointed out that day.
That's all right, my lord. Be that as maybe, my lord, I have obtained a document, my lord.
A copy of the report may be given to me.
Yes, yes,
At least I should have.
And
no,
show me.
nothing is there, my lord.
Nothing is that I have to look into the report, what
Where it is
report has been given. I have to look into the report. What is, nothing is there that is for you, but something is there for me. What you have sold, that is not our property. You have sold the property of others. One of my concerns will be printed in liquidation along. Give a copy, please. How much profit will be made?
Page 330.
Report.
In compliance with the lordship, the fact is from paragraph 1. Possession of the public premises involved in PPA such and such was taken over by the estate officer, Kolkata Port Trust, through its authorized officer appointed under Rule 7 of Public Premises Transfer and enumerated condition with the assistance of the Westport Police Station. Next. In terms of the statutory requirement, issuance of the notice before disposal of any property mandated in Section 6 of the Act for issuance of a notice under Section 6 of the PPA transfer proceeding number transfer by the estate officer for disposal of the property based on the public premises by the your lordship judgment whether the Section 6 notice was given or not. It was notice was published in newspaper as well as ethics. Thereafter, the statutory notice under Section 6 has been published in the Delhi newspaper, the statement on such and such, giving 14 days time to such Trade CI Limited. Trade CI is not my lessee. My lessee is on a Trade CI my limited. Yes, man, it's my lessee. On my other interested
That is the crux of the matter.
Materials with the written authority, estate officer provided any areas damage till date. Trade CI India nor any other interested party, entity, except one Metro Emporium LLP. I have a judgment in this. LLP has approached the estate officer for removal of the goods submission. He filed an application Metro LLP that was also dismissed. Then the matter regarding the disposal of the goods material under Section 6 will be taken up by the undersigned expiration of 14 days from the publication of the notice. Following due process of law, provided there is life are rested from the civil court from the law, the undersigned is having administrative hours to answer. Next matter be as it may be in compliance of the order number such and such, the report of the investigation, inventorization of the goods and materials lying of the public premises involved with the instant process is enclosed herewith. Duly countersigned by the undersigned. We mention here that as per the direction, Your Honor, prior notice was served on all concerned by Trade Limited, which was repeatedly refused. It is reported that nobody had turned up on the date of inventorization on such and such date, except representative of KOB. Accordingly, the inventory was carried out. Next, last paragraph 8. It may be here. Trade Limited, Mr. Trade Industries were also occupants in respect of an adjoining public premises. Forward under the different plot number PPX 127. Thereafter, now the inventory is complete. Now the question is selling auction. Auction has been completed. I will show you the document. After this auction, money has been received. What is my due? 30 crore. Out of that adjustment till now, what I am entitled to get. Any after now, Lordship, stateway, this fact also stated here, my lord. Lordship, kindly come to page. My lord, page 17 first of my bunch of documents.
With due respect,
let me whatever you
may make one humble condition. Since the report has been filed before last.
This is not a report. This is not a report. Not I have been disclosing some documents.
Mr. Rai, if the food trust comes and says that they have sold everything and they have documents to show that they
Page
have
page
sold.
20.
And in any case, Mr. Rai,
Page 20.
for documents, just for your satisfaction, I had called for the report. I have seen the report now. In any case, not the report, the document. If you want to take back the goods, even if you wanted to take back the goods,
No, I want to file an exceptions to the report.
no,
But
this
what
is not a report. I'm not
what is
inclined to go into this.
What is confusing your lordship will kindly,
Your lordship
your
judgment.
lordship will kindly, lordship will kindly see.
If you
The
have,
series of judgment.
you have any right in respect of the property.
I have.
Kindly
You
see
ought to
page
have
20
claimed
माला
at the time of sale.
page 20 हम तो बोलते नहीं तब आपने बोल रहे हैं देखते नहीं डॉक्यूमेंट देखते चाहिए हम देखते page 20 का lordship consider page 20
Yes.
kindly see माला bottom reference to training में as detailed so it is the material manager undersigned below auction held on 23rd October 2019 we are in 2026 so sale price of the against 6 lots furnished below 2 plots are there 161 162 all plots is there what are the amounts now your lordship kindly this is the amount adjustment this amount is due page 22 39 crore 28 lakhs last column total dues after adjustment now my lord now this is the now your lordship can see your lordship judgment on that is the last day of that
What is the prayer in the writ petition?
prayer in the writ prayer peculiar prayer lordship can see the prayer not maintainable at all a writ of mandamus which is so each of one of them cancel cause forbear recall to give effect further effect to the impugned action
Sale
of
has
the
already been conducted in 2019.
no, what I mean, who is asking? He is the report just now 332. That is the report. He is asking for quashing. That is a subject matter of the section 9 applications. And a writ court. He is asking for quashing of this. And that appeal has been dismissed. How can it be, my lord? I do not know. How the writ is maintainable at all.
Yes.
I am not citing the judgment, my lord. So many judgments.
But I think that when judgment has completed his submission. What is trying to convince the lordship, Lord? I'm putting this question to myself. Whose property they have sold?
Whoever it
No, Lord,
writ court will not decide that.
Strangers property, even a stranger
He has-
are lying.
He has sold it in auction. He has given the plate numbers. I will not decide that in.
No, no, your lordship can't
I
kindly
cannot decide
appreciate.
these disputed questions. of
Lord,
fact.
these are not at all the disputed questions
Of
of fact.
course it is
Your lordship may kindly, your lordship may kindly
Property
come
is
to the
good
report.
identity.
Your lordship kindly come to the report. The report submitted by them. Just a minute, please. This is the report which you have submitted.
This is not a report.
That
It is just his instruction. There was no direction for filing report also.
no, there was direction.
Not for filing report.
Lord, your lordship will kindly say, if State Officer Calcutta put this, may hand up this copy. Lord, your lordship can excuse me that I have marked at some places. Lordship will kindly see the report. Please, lordship, please. Lordship will kindly excuse me for marking this pen.
This was shown just now. It
No,
is a part of
no,
your writ
lordship kindly
petition.
see the
It
last
is a
page.
part of your writ petition, Mr. Rai. It
Part
was
of it
shown
is-
just now.
No, lordship kindly see the last part of the report, last part of the
Yes.
Lord, the publication is given that they have sold given the advertisement for sale of the properties of Mrs. Krebs Company India Limited. But we are not the Krebs Company India Limited. We are Lord, that we are the Krebs Manufacturing and Services Limited and another. Krebs Company was there previously, Lord, that went into liquidation. There was a merger also.
Mr. Rai, please see paragraph 7. It names your also. It names your company also.
My company, but the goods of my company have not been sold.
No, no. That how will I decide that?
The
The goods of
publication-
your-
the
Even if
publication
it was not sold, you take steps. If it is not sold, you approach them. How can the record decide all that?
Let me humbly submit. Lord,
No, no, Mr. Rai.
Lordship will kindly appreciate, Lord, that they have given the publication for selling the properties of the Krebs, the company which is not at all in existence, Lord. But my goods and other things are there. Lord, and they have deposited as per the court's order, Lord, honorable High Court's order, they have accepted from me 1 crore something. That is the order passed by Justice Dipankar Datta and Justice also. That a receipt copy I have annexed to the petition. When they have accepted the money from us pursuant to the order passed by the Honorable High Court, so they cannot take this plea that we have told this case signed. That has nothing to do with us. So in the garb of selling the properties of that company which has already been merged, there was a merger and BFR proceedings were started, Lord, and you are selling the property of this. You have not sold my property. You sold single paper that yes, advertisement has been given in your name that your property will be sold. Then I am out of the court.
Well, I'll show 2 line of the judgment, 2 line.
Judgment
That your lordship has considered paragraph 23, last 2 lines.
From this publication,
Last 2 lines. Paragraph 23, last 2 lines. Last 23, last 2. The estate officer under section 6 of the PP Act is entitled to sell the goods even of a stranger found in on the premises under unauthorized document.
And without publication,
that judgment has been considered by your panel
without giving me any opportunity.
No,
Without
that
publication.
was the case. No, who is he?
If both of us
And
talk
the
at the
section
time,
notice was given. He has to appear before the estate officer. If he do not pay the decretal dues, he has to participate in the tender.
If both of us speak at a time, it would be difficult to decide. Lordship, from the advertisement to Lordship can you see where does my name appear? Where does my name appear that any advertisement was given in my name that your property will be sold?
I don't have any extra thing.
You have no nexus and you are selling the property of mine under the garb of fifth CIA. The company which is no longer there, the company went into FIR and in the FIR. Lord, I shall be paying before Lordship, Lord, I shall file an exception to the.
There is no report. What exception will you file to the document?
What they have submitted, Lord, I'm begging Lord, your Lordship, can you give me a fortnight time? Lord, I will go through it and I will submit the correct picture before Lordship. Everything will be clear. In the garb of CIA, you will sell my property and you have accepted the money from me under the court order, under the Honorable High Court order, and that you have accepted and you have issued the receipt to us. Where you have found that yes, proceedings were started against you, and in execution of the proceedings that we have sold your properties? That cannot be done. That X has gone suffered the decree, and my property will be sold. Lordship, can you give 2 weeks time, Lord, I beseech your Lordship, that in the garb of selling the property of somebody else, they will sell my property also. We are governed by the major court. There is ample provisions.
Where are the orders passed by this court on which you were relying?
Lord, the payment which I have made, Lord, sir, can you give me the minute's time, Lord? Just a minute. Lord, sir, can you give me? Yes. Page 323, your Lordship, can you see? Page 323 of my writ petition. P10. 323. P23. Yes. P10, page 323. Whose money is this? Manufacturing Services Limited. This is my company. You have accepted the payment of 1,03,12,446. Is there any order or publication that your property is also going to be sold after having accepted more than 1 crore?
Please wait, Mr. Please wait. Let me read.
Then, Lordship, can you see? Very statutory body. You cannot act in this way. advertisement actually the company to below here. Therefore, the therefore it was sold and it was sold to us. তোকে বলছে কি এখন প্রসেস আমাদের বিরুদ্ধে এখানে this order you have to read from the page 210. Different plots for the occupancy mistake adjoining public premises covered under different plot. Where in the different plot? Different
But Mr. Jana, what about your notice? Your notice only refers to Krebs Sai.
my lord.
The notice
much
does
better,
not
lord.
say any other person.
The mind lady is the trade. My lady is the trade. API in the trade.
No, but
The original proceeding, original, your lordship kindly see
But
the
wait, Mr. Yes.
original proceeding against the crepes here, not scrape manufacturer. Your lordship, I see that order also. That order 223.
Okay.
Any order 220, 240, any page, 223 at the top. Each order, the crepes is the original list.
222.
223. The proceeding against the case here.
Proceeding is against script PI, there is no doubt about that.
Yes, my lord.
But the section 6 notice should name at least if it is not
And
there,
he
the
appeared,
omnibus.
he appeared before the state officer in the section 6 proceeding.
He appeared.
Yes.
Show me that.
He
Then he
appeared
has
in
knowledge of that.
section 6 proceeding followed by shown your lordship.
Show me that. That ends the matter then.
The notice was affixed at the premises also. Notice also affixed in the premises. Notice also.
Show me where he appeared. That will put an end to the matter.
Yes, my lord. Page 13 of my document. This is a section 6 proceeding, page 13. Who are appeared? Number 4, Mr. Scrape Manufacturing and Service Limited, represented by Kaustubh Majumdar Advocate. Mr. Majumdar Advocate appears without Kokalama files 2 numbers of applications containing pre-intent not to pass any order release of any goods and material. Notice was issued. He has a knowledge about the notice. Pursuant to that notice, he also appeared. Paragraph considered the matter, the basis of the document and the materials on record. It is still now 16 edition, DPR report consultants. Everything has been recorded.
Yes, Mr. Rai, you have knowledge of the proceeding.
Thereafter,
Because your name is not there in the newspaper doesn't make any.
No, Lordship kindly.
it is why legislature intention published in the newspaper, affixed in the wall. Everybody interested party will come. Either notice up to him or not.
I'm not going by the words of mouth. Lord, I'm relying on the paper only. This notice of auction.
It is irrelevant, Mr. Rai. If you have participated in the proceeding under section 6, that is a notice under section 6. That is a notice under section 6, nothing more, only to put it in your knowledge that we are going to sell it. You have participated in the proceeding where under this decision was taken that the properties are going to be sold.
That has not reached its finality.
Lord, can't say that.
That has not reached its finality.
It has reached.
Once again, I am trying to your lordship, to do your lordship's attention to the report. It is reported that goods and materials are also lying in that said public premises, and accordingly separate proceedings under section 6 of the Act in inventorization, etc. are underway. This is with regard to our company. And
this report was filed on 24th of April 2018. You participated in the proceeding on 7th of May 2018. Therefore, it is prior. This report is prior to the participation. Your participation is later. You were in the know of this.
Lordship kindly appreciate. Lordship kindly appreciate.
Difficult.
The proceedings will start only after the publication and the possession is taken. If there is no publication of notice or sale.
You have participated, you have knowledge.
No.
You ought to have.
I had knowledge or no knowledge, that is not a thing.
That is the thing.
No, the
that is not the other thing. That is the thing. If you have knowledge, the notice is only for knowledge.
Question of law is there. The notice has been given in respect of the access size. It is not in respect of
not required. Even you had knowledge, even if the notice is defective, that does not lead anywhere. There is no
in the garb of the notice to a company which has already gone into merger or there was a BFR proceeding. The company was no longer there. Company was no longer there.
You had
I have stated all things
that they are proceeding against.
I have stated everything in my petition. That BFR
you proceeded, you appeared in a proceeding which was against Krebs I only. The proceeding was against Krebs I only. You appeared in section 6 proceedings against Krebs I only.
If I
No,
have
Mr.
not
Rai,
given opportunity
this
to
is
discuss
trying
the
to
doubt.
take undue advantage
No,
of
no,
some
Lord,
infirmity that
Lord,
may be there in the
Lord, kindly appreciate, Lord. Lord, the crepe tie is no longer in the picture. It
You
went
have
wrong.
appeared in that proceeding, sir.
I have-
No, you have.
I
That
was,
is
I
the
was, I
document.
was not representing
That
the
is the
crepe tie.
document. You see the bunch of documents, it's there.
Lordship, no. Lord, what I'm humbly submitting. Lord, in notice suppose you Lordship.
Sir, Rai, we unnecessarily wasting
No,
time.
Lordship, kindly, Lord, unnecessarily wasting your Lordship's time, Lord. I do feel sorry for that. But Lordship, kindly give me 10 days time. Only 10 days. That can be done. That can be done so that I can.
Next week, I'm fixing it. You consider
Yes.
the documents and come.
My Lord. Because
Mr.
They have filed
Mr.
series
Sinha,
of
learned
litigation.
advocate, appearing for the petitioner, appearing for the respondent.
What for you are
Please wait, let the court also dictate.
Okay.
Mr. Jaina, learned advocate, appearing for the
For a quashing of the report which was filed in a section 9 application.
there are enough provisions are there.
wait, period हो जाओ. पूरे चले आज. हाँ. 12 ना. ये कॉल करो, लिस्ट कॉल करो.
My lord, I am for the petitioner, my lord.
Item number 863, my lord. For the Jila Person, my lord, Marine Council, Mr. Tapas Mandal is appearing, my lord. He had informed me that he couldn't come to court because of his daughter's ongoing higher secondary examination. Now, I'm praying for a week's accommodation.
Very well. An accommodation is prayed for on behalf of the
my January first order, my lord, it was stay for the limited period, my lord. Stay of the operation of the order, my lord. Kindly have a look. ওটা না দিদি 683টা ওটা না দিদি হ্যাঁ 83টা হুম আমাদের কত 25 মান সিং লিখেছিস কি দেখ on that day, my lord, I am could not appear, my lord. My friend appeared in the on my behalf, my lord. Not been. Definitely. Oblige, my lord. Definitely. আপনার নামটা কি?
My lord, I am appearing on behalf of the petitioner, my lord. On the last occasion, my lord has handed over some orders to us as it was directed. My lord, I need some time to receive the instruction, my lord. I'm taking a week's time.
Time tells. I have handed over the document long back on the very next book. Kindly record that we have handed over.
Two acts, my lord, for removal of the unauthorized construction. So erected over the iron all not.
Milord, we have fixed a date, Milord, that is on 17th of February by the BLRO, Milord, for demarcation of the land. Because mapটা বার কর না তোর এটা তো Milord. Milord. So the allegation is there is a plot which they say belongs to the state. That's why, Milord, we had advised the officers to conduct a
Yes. Miller. Miller.
I am personally agree. My fault.
If it is a state land, Miller, there is money. And if it is on the state land. Yes.
All the
চলে যাবে কি? চলে যাবে কি করবে?
এলাহাবাদটা দেখো। But on the last two occasions, Millard, I have virtually concluded. First submission was, Millard, where there is a dispute as regards the title of the property, Millard, whether it civil court. The second is assuming the Public Premises Act applies. Then also, Millard, section 27 of the limitation. No, no, what চলবে না। Right. 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 These are the two fundamental submissions where no, 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 আমার হয়ে এসছে। Yes. Yes. But only one judgment, Millard, of the Allahabad High Court, which considers all the judgments. This is of 2014, SCC Online Allahabad 16024. Millard, an argument, Millard, I am preempting is that since in the GLR records, the name of the cantonment board or the that military department is there, therefore the property is to be presumed to be a public property. This is an argument which I am preempting. Therefore, please consider, Millard, paragraph 15 of this judgment, 1-5. But here, Millard, the Allahabad High Court was considering, Millard, the applicability of this 1971 statute. (15 and 16). Before considering the question whether proceedings under section 5A and B are applicable in the case in hand, it has to be first seen whether the property in dispute comes within the definition of public premises or not. Petitioner is claiming that the property in question was purchased by her mother-in-law in 1940 from one Ilahi as freehold property. No material has been shown by the respondent to show that the land in question is a public premises. It cannot be presumed to be a land either belonging to the government of India or leased or requisitioned by it. The mere fact that the land is within notified civil area of cantonment will not make it a land belonging to the government of India, inasmuch as there exists certain private land also within the cantonment area. Onus lies upon the government of India first to prove that the land in question belongs to it so as to attract the provisions of the Act of 1971. In the present case, despite the fact that no cantonment grant was placed before the authorities below, no other clinching evidence was placed by the respondent, yet it has been presumed that the land belongs to the government of India, and thereafter authorities have proceeded. The question whether the land belongs to the government of India or not is a jurisdictional issue. Summary proceedings under the Act of 1971 are initiated only in respect to public premises and not otherwise. Therefore, whenever any proceeding is proposed under the Act of 71, treating the land or building to be public premises, but if the occupant seriously opposes, it would be the foremost question of importance to be seen by the authority concerned whether it has jurisdiction to proceed with the matter or not. In the context of the Act of 1924, similar view has been taken by the Apex Court in so and so wherein the court held that in absence of any material placed by the occupant
to show its title while cantonment authorities placing old record of general land register containing entry in regard to title in favor of the government of India, the evidence adduced by the cantonment authorities can be relied to hold title in favor of the government when nothing otherwise is placed by the occupant. This is very important. Because GLR itself will not lead to any presumption. GLR, you can look into it provided the other side does not provide any document. In the present case, the stand taken by the petitioner is fortified by certain land deeds placed on record. On the contrary, respondent cantonment authorities have not been able to place on record the old grant contract terms in respect to land in question and instead have relied only on the entry made in general land register, and that too in 98. Prima facie, I am of the view that the respondents have not discharged onus lay upon them to prove their title credibly and effectively. However, I am not expressing any final opinion on the question. In my view, issue has to be decided in an appropriate proceeding by the forum concerned and not in a summary proceeding, and more so in the jurisdiction by this court. Suffice to mention that the petition in respect of such and such, I don't will trouble you with the rest of it. Therefore, this GLR entries can be looked into to presume ownership of the government or as it to be a public premises if the other side or the person claiming title does not place anything on record.
Proceeding, he has made his mind clear that according to him.
Therefore, Millard, I am seeking for an interim order, Millard, for the present, Millard, directing Millard the estate officer not to proceed with the impugned notice any further. And there is another, Millard, I call it a prejudicial fact, that these three sequential notices itself is, Millard, a demonstration of a preconceived mind. Yes. Well, we have the title deeds made. If your lordship so desires, Millard, we can place it before this court. We have
They
it.
should. It is not about seeking permission from your lordship because they are the lessees. The title deeds are a must, my lord, to establish their case.
These are all registered documents.
Maybe.
My learned friends, clients.
Maybe we do not know.
A
You should have given
GLR
a copy to me. I could have seen if they are material or not.
But these GLRs, Millard, are not registered documents. As your lordships know, Millard, title passes through registered document. That is the purpose of registration. And I am a lessee, I have an occupational right, definitely. Lease, as your lordships have held, is a bifurcation of ownership and possession. I have a possessory right over the property which presupposes that there is a lesser and an owner. And I have shown from their document, they have accepted in Koto Kunsale Chilo Shira, demolition proceeding, that the Rokhits are the owner. Just Millard, for recollection, please have a look at that document, demolition order. Yes, please take Millard once more. Demolition order. Just give me a moment, Millard. I've lost that page.
Page 152 ta ki? 152 ta?
Da.
Dekho ekbar 152 ta dekho. Appellate, Office of the Appellate Authority.
কোথায় গেল
152 না? 150. Printed page 152.
Oh, printed page 150. Yes. My lord, may kindly, my lord, I've already placed it. But the printed page 152. Yes.
Volume 2.
Please take the penultimate paragraph over here. It is, yes, it's their document. But these are my submissions. May I have your lordship's leave? If your lordship requires, my lord, any response from me, my lord?
No, my lord, I can show, my lord, at this stage, my lord, the previous benches were of the same opinion. At this stage, if your lordship goes into the merit of the case, then, my lord, the officer there will be precluded from taking another view. So only thing to show for me to show is that at this stage it is not, writ petition is not maintainable.
Not required.
Yes, my lord. Yes, my lord. Yes, my lord. Yes, my lord. My lord. And this issue has also been settled by the division bench, whether it will be taken up by the this court or the officer. That has not, division bench order has not been appealed. My lord, kindly come to page 90, my lord. I'll take half an hour, my lord. I'll try to minimize it, my lord. I'll try to minimize it as much as possible. Yes, very well. As your lordship will direct. Huh? Very well, my lord. Kindly give me next Thursday. Next Thursday.
Proper return করবে কি?
এরকম জায়গায় যা
Lord, I'm 67. Hello. Your lordship, my lord, the order impugned is the order passed under appeal by the my lord, district magistrate under the my lord, under the my lord, it was Mr. Lolit Mohan Mahato is the state. I have been told that there is a junior on his, they appearing with a junior. Yes, my lord, district, and the issue, my lord, as it was initially filed before the my lord, court number 90. The court has, my lord, released the matter because yes. Now, my lord, only one thing, my lord. My lord, SDO, SDO. Then, my lord, the appeal was referred. My lord, and my lord, another issue just I want to point out before my lord, only one thing kindly for once, because this particular, under this provision of the act, this particular proceeding cannot be, my lord, initiated. This was the, yes. My lord, just, my lord, I'm making, my lord, answer to the query, my lord, before, my lord, just before that, my lord, for once, my lord, my lord will take a different view, because in the earlier round of litigation, kindly consider, for once, my lord, kindly consider, my lord, kindly consider, my lord, the order passed by this honorable court in the earlier round of litigation, page 36 onwards. My lord, the page 39, the order, the ordering portion, my lord, is started page 39. This is on, this order was passed in the earlier round of litigation, filed by my learned friend. Page 41, my lord, kindly consider paragraph 10. Kindly consider. Paragraph 10, my lord, if they are find merit in the case itself, the court had directed that before parting with, it is made clear that in the event while passing the reason order, the respondent number 4 authority finds sufficient merit in the representation dated such and such, he is directed to proceed in accordance with the provision of section 10 of the West Bengal Highways Act 1964. Now, in pursuant to this order, this entire proceeding was, my lord, initiated instead of Highway Acts. They have initiated proceeding, my lord, under the, my lord, a public premises eviction of unauthorized occupant act. This is the moot question, my lord, and there is a finding this particular plot is coming under the, my lord, provision of the Highway Act. It is not is a public land. It is a Noyanjuli. It is attached to, my lord, a highway. It is completely coming under the Highway Acts, and the court, my lord, Mr. Mahato is appearing. Mr. Mahato is.
Page 45. He has admitted he is occupying the PWD.
There is a, first of all, my lord, there is no jurisdiction at all. It is a completely illegal order from the very beginning.
Page 45. It is the order of the subject. Here is the inquiry report of the BLRO. BLRO concern as per that the subject line, that is plot number, recorded for the PWD. PWD land, and same has been unauthorized possessed by the unauthorized occupant, that is the petitioner. And they admitted they have been possessing or occupying the subject land unauthorized. Seized law. In this contention, they have verbally admitted and agreed to remove.
And now that I'm.
I beg to appear for the petitioner.
I am for the respondent. I think all the respondents, except
State not.
this is still authority of India. I am appearing for
Public. Public premises
by,
unauthorized occupant.
before my there is one point of maintainability. If your lordship allows me, so I can. My lord, this has been filed under Article 226. Now, lordship, can you see the prayers? Read and your nature of mandamus 1, agents, further effect to notice dated 19/4/2022. Next. A writ of mandamus in the nature of mandamus will issue for respondent for order dated. This is the state officer's order. Writ of mandamus certiorari the appellate authority's order. As your lordship knows, the appellate authorities has to be challenged in 227. I have a judgment of my Lord Supreme Court. Lordship. Yeah, judgment about. My Lord, I'm showing only one judgment because this is 3 judges bench. It is the life insurance, Life Insurance Corporation of a Basir Nandalal J. Shah. Nand 8 and 8. Lordship, kindly turn to just paragraph 55. I will shall not trouble 55. I shall not trouble your lordship. Here also section 9 appeal was there. Paragraph 55. It starts with 50. I'm just showing the
Yes, Lord.
yes. Please come. 58, paragraph 58. My lord, Radhesham is there, and subsequently, my lord, I also this was happened that time. Must have been. Deepak Mishra's judgment also was filed writ petition. And thereafter, my lord, withdrawn again to 27. This is judicial order, my lord. It has been said that is a court. Court, my lord, is a judicial order.
Lord, the question is here, Lord, whether the appellate court is exercising the jurisdiction as a civil court as a persona designatum, Lord.
Placitum, my lord, the lordship kindly turn to 365. Placitum E. Radhesham has been found. Not only the facts are also very. They have filed a suit. Came into 27. That has been dismissed. Appeal dismissed. Again, my lord, this is the third round is going on. But fortunately, some documents were.
Lord, may I come back? I have a judgment, Lord, where the Honorable Supreme Court has held that. Lord, may I come back next Thursday? I have also.
Still authority of India. Respondent number
So 5. Yes, my lord.
Then I am for petition. Yes.
I for the respondent number 6, my
The application.
5, my lord, the police authority has no role. But I need the respondent number person 3, my lord, is due. I need the report for issue, my lord. I got only report for 5. Yes,
Yes, yes.
yes, my lord.
Page 27 is the report.
I'm for the petitioner. Ma'am. I have served. Huh? 870.
My lord, I'm for the I will respond.
On the last occasion, Your Lordship, the learned advocate for the state, he was not there, and we have given the notice. Today also, I don't think he's here. We have given him the notice, Your Lordship. It's a matter of illegal construction on the road, Your Lordship, as a result of which my total ingress and egress has been stopped, Your Lordship. I'm making an eye hospital, Lordship.
I will respond.
State, they Ananya Negi, and she told me over the phone that Mr. Sudipta Pandai, I think he is appearing, I think, Your Lordship. That is there. Where, Your Lordship, I'll otherwise next week, Your Lordship. I will like it.
Better to next week.
I'm for the petitioner, my lord. I have served notice, my lord. All unauthorized occupants made by the private respondents in the front of the petitioner's lawyer on the government land. Your petitioner made a representation before the authority concerned, but not considered till today, my lord. Yes, my lord. Representation dated 1st July 2025, page 13.
all the respondents, they are received, my lord. My lord, kindly see first my representation, kindly see Annexa P3, page 15.
The 72, my lord, I appear on behalf of the petitioner. My lord, this the problem, my lord, is this, my lord, I have, my lord, it's a good 9, my lords. My lord, I have some, my lord, only one line is order is required because, no, my lord, this is further, sir, because of that, intentionally, the private respondent refused to accept the letter. And another thing is the same brother is stated in that, my lord, the envelope that insufficient service. So, my lord, once again, I have to serve the, my lord, once again, I have to serve the private respondent. Lords, my lord, lords. So, my lord, since I have not, my lord, filed the affidavit of service, next date, my lord, I will file the composite affidavit.
I beg to appear, my lord. My lord, it is an, my lord, writ petition, my lord, under my lord.
Of the private respondent.
West Bengal, my lord, eviction of unauthorized occupants acts, my lord. That the petition.
No,
It is. It is. Perhaps it is group 1, my lord. এটা কি কিসে ছিল?
It is residuary non-police.
ও ল্যান্ড আছে তো?
No, আগে there was a dispute. তারপর it was held.
Yes. All parties are appearing, my lord. Yes, that will be done. Yes. Yes. My lord, petitioner is the owner of plot number 131.
Taking a point of maintainability, my lord, if my management intends to argue, my lord, on facts, my lord.
I have made complaint that in front of my land, there is a land of the irrigation department on which the private respondent encroaching made construction of unauthorized encroachment. This is the matter.
But in terms of the pleadings contained in the petition, as well as, my lord, the representation at page 37, the writ petition on the face of it is barred, my lord, owing to the operation of, my lord, section 34 of the specific relief act. Because, my lord, the petitioner admits in his averments as well as, my lord, in the representation which he has made, that he has no legal character, where, my lord, the land for which, my lord, he is moving this particular writ petition. Moreover, my lord, he has tried to create a confusion by way of, my lord, jugglery of words, my lord. English, as we know, my lord, is a very complicated language. He mentions it's a public road, but he mentions the plot number. My lord knows it very well, my lord. Roads do not have plot numbers, my lord. So he says, removal of unauthorized and illegal encroachment of government land at Mouja such and such, being plot number 132, Mouja such and such, Purvo Bendipur by such and such, the private respondents. So this is his basis of complaint, but in the letter he states that it is a metal road. And that apart, my lord, so my lord, first of all, my lord, he has to overcome this particular hurdle because
Yes,
it's being
yes.
hit by section 34 of the specific
Yes.
relief act, my lord. Because he cannot seek for a declaration. And that apart, my lord, no, for seeking, no, my lord, for seeking, my lord, action, he has to establish a right, my lord. Otherwise, he has to move a public interest litigation. He has no admittedly, my lord, no locus standi. And that apart, my lord, he is deliberately, my lord, doing it, my lord, owing to rivalry between, my lord, interstate, my lord, the parties, the private parties, the petitioner and, my lord, my client. My lord, I say, my lord, it is not an encroachment, my lord. And that about, my lord, I intend, there is no prayer for any interim order also. He has made a prayer for ad interim order. There is no interim order that has been prayed for. No, my lord, but the representation does not state, if my lord kindly takes pain to come to page 37. Yes, it does not say or does not speak of initiation of action under the Public Premises Eviction of Unauthorized Documents Act. Okay.
Government land.
No matter whether it is for the state to apprise, whether in respect of the alleged encroachment, whether in respect of this particular plot, no, whether this act at all applies or not. Because there is first of all no mention, my lord, in the body of the petition also.
My lord, may I?
In the body of the petition also, if my lord kindly takes the prayers, in the prayers also, my lord, there is no prayer, my lord, for initiation of action under the act. It's a simpliciter prayer for initiation of appropriate proceedings, my lord. Yes, and he has filed it, my lord, under group 1, knowing it very well, my lord, that this is not, my lord, under, my lord, the provisions of the special law, but this is a land matter. So it was, my lord, not, my lord, an innocent inadvertence that I will say. Yes, but it is filed essentially under group 1. He might have written, my lord, but I do not find, my lord, from the pleadings, my lord, anywhere in any of the paragraphs, my lord, he has mentioned there is a whisper also about this act, my lord. Neither in the pleadings nor in the representation.
My lord, may I give the short answer? If required, my lord. Yeah. First of all, my lord, as my learned senior friend says, that the government road or government land does not have any plot number. It is absolutely, my lord, not understand where from he says so. Page 34. In each and every plot, even the national highway, there is a plot number. My lord is well aware of this. Page 34 is the plot number 131, which I have stated in my writ petition. Bad.
What is Bad?
Bad.
Bad means
And
dam.
it is under the Paschim Bongo Waterways Department, Rajya Sarkar Daftar. And my lord, I have annexed the map in page 35. In the top corner, my lord will find, my lord, I have, in my copy, I have indicated. This is the, that, my lord, is plot number 131. In the corner, top corner, my lord, 132 is my plot. So, each and every plot, even it belongs to whoever, plot number carries, my lord. First, so his contention that the plot number is not there, is government plot is not there, it is not that.
I said the plot is not a metal road. Yes,
I said, no, I said it is the land of the irrigation department on which a metal road has been constructed. My lord knows, my lord, in the rural area, that is river bank is there. Usually in old days, my lord, it was mud. Nowadays, since the publics are passing by, it was previously was, my lord, Moram road, and thereafter it has been made, my lord, public road as. So nature of the land is mud, and they have constructed illegally encroached on the mud land that is belongs to the irrigation department. And I have shown the map. It is in front of my. I have required access from my land to go out from my land. The government mud or government land is required. So, my lord, I approach to the authority seeking appropriate relief. My lord knows, my lord, statute need not to be mentioned by which, my lord, it is required. And the act itself very much clear what is public land under section 27, my lord. May I hand over? Except the, yes, except the Bengal Highways Act, all other lands are the public lands. When, my lord, it is under the irrigation department, so, my lord, the appropriate proceeding would follow under the specified act. Yes, it is West Bengal Act. And accordingly, I made concerned authority, district magistrate and subdivisional officer as the collector in the, as per the act. So, and I have come up with inaction. When with the documents I have said that there has been unauthorized encroachment on the government land, which blocks my ingress and egress, even ingress, egress, even not block, even a passersby who occupies the road or occupies the for public purpose, he can raise the point that a person and unauthorizedly, my lord, raise the, because he feels, my lord, difficulty to pass by. So the writ petition is very much maintainable, and it is come up under Article 226. And, my lord, if there is any regarding Group 9, it can be corrected.
My lord, I have got the statement. I have only the report from police authority.
I have made the jurisdictional block and block land reforms officer party. I have made the,
Yes. My lord, my simple contention is, my lord, there is no, till now, my lord, there is no initiation of action even vis-a-vis the representation, my lord, under the provisions of, my lord, the West Bengal.
my lord, I have made the block land and reforms officer also party. Yes. Yes, yes, yes. Yes, yes, my lord will pass that. Yes, yes. Yes, yes, absolutely. But, my lord, he has not answered to the my lord's query whether he has occupied on the government land or not. He has not answered on that.
Let him consider the representation, my lord. My lord may kindly clarify that my lord has not gone into the merits, my lord. Since, my lord, no affidavits are being called for, my lord.
Yes, yes, absolutely. Okay.
But does not include government road or highway within the meaning of Bengal Highways Act or any law for the time being enforced. So, my lord, may kindly also, my lord, clarify, my lord, I'm beseeching your lordship that my lord has not also gone into this aspect as to whether this act will apply or not, my lord. Because there is a dispute, as I pointed out. He's
My lord,
on one hand,
I said.
On one hand, he's saying it's a plot, having a plot number. On the other hand, he says that it's a metal road. The plot is a metal road.
My lord, what I said, my lord. He is, my lord, trying to make out a otherwise case, my lord. But I am giving just answer, my lord. Yes, absolutely. But I have shown the, it is irrigation department on which a metal road is there. And that land belongs to the. But Highways Act. আমার দেখা যায়, তুই বল।
74.
So Mr. Bhattacharya got stuck in court number 11. He is requested for a 1 day time. But tomorrow it will be possible.
Your Lordship, we are praying for 1 week time, Your Lordship. Kindly keep the matter next Thursday. We will have to look into the notifications and we will come on next Thursday, Your Lordship.
The other, my lord, they are carrying on business, their wrongful occupation. My lord.
Your Lordship, 1 week, nothing will happen, Your Lordship.
I'll wait.
Shut down of the establishment, nothing will happen if you say so. Let all the establishment be closed.
Mr. Banerjee, we are requesting for 1 week.
Whenever you lordship, I don't have a problem.
Can you have it on Monday?
Your Lordship, no problem.
Huh?
Kindly keep it on Monday. We have got no problem. Kindly keep it on Monday.
সোমবার দি সোমবার উপরে দিয়ে দেব
I'm grateful.
ওই
I'm
আর্জেন্ট
very
আর্জেন্ট
Great.
ম্যাটার গেটিং ইট
very kind.
Grateful, Your Lordship.
আরেকটা কল করুন 14 হচ্ছে তো টাইম আছে
Your Lordship, sorry for.
লিস্টটা চলে গেছে বস দিদি লিস্টটা চলে গেছে লিস্ট
Your Lordship, sorry for interrupting in the last matter. The interim order will stand disposed of otherwise unless orders are passed otherwise.
Monday it is going to be taken up. 2-3 days, what will happen? আমার লিস্টটা চলে গেছে ওইদিকে বললাম তো ফাইলের সঙ্গে লিস্টটা চলে গেল না বললাম যে লিস্ট চলে গেছে 874 demolish so it can be done away with লিখে নিন this writ petition has been filed seeking direction on the respondent state authorities to take steps for demolition of unauthorized construction over government land. Full stop. Paragraph. A learned advocate appearing complained of has already been removed. Full stop. Learned advocate appearing for the petitioner.
My lord, 870 for the state. Order has already been passed, my lord. I was engaged in court number 40.
871 what I have done, I don't remember. ওই রিলিজ ফিলিজ কিছু হয়েছে না 871
May I be permitted to give my name?
No, no, if service has been directed to be done. No, no.
That's 87. 86.
কত হচ্ছে এখন 874 হলো তো
875, my lord, I appear for the respondent. That's state.
The other side is not there.
Right.
It's
But
free.
from 2 PM onwards, my lord, other matters will be.
All parties are not there, it will be difficult.
Already time is.
Yes, if all parties are not there, it will be difficult. Yes. Yes.
GM has already passed the fresh order and I'm carrying your lordship's judgment. The last day your lordship wanted to see. And on
What order?
11th of February 2020. In respect to the second application, they have passed fresh order, and also in respect of both the properties for restoring the earlier property, and also and here is your lordship's order.
We are really embarrassed. And also a bit relieved, yes.
I hope my lord was referring to this judgment.
Yes, this is reported in SCC online. I've seen that. This exactly was the point which had fallen for consideration. You've seen this?
Yes.
My lord, yes, and this has also been referred to in only will. Only problem is in SCC. Yes, in SCC online there is a wrong reporting of the read number because I tried my level best to find out from SCC. It's very
No, it's
difficult.
there. I had seen it because I had used it in a different
Yes, but
matter where
when we tried to find it out from SCC with this number, etc.,
because this
shows,
was
but
done
the-
at a period of time when DRAT was successively dismissing applications on this functus officio. This expression was being used. DRAT was blissfully scotching. So when we got this order, and this order was passed, we utilized it in several matters there.
Yes.
That this functus officio doctrine is not proper.
Not
because that is not the right reading of section 14.
It's a ministerial job. There is no doubt about it.
Yes. After this Tarle judgment, Ramakrishna or something, Tarle.
But finding this in SCC is a bit of a task because there has seems to be a wrong reporting in SCC.
Yes.
If we go by the numbers, etc., something else shows for some.
So your grievances now, I think, should be redressed because they have passed a fresh order.
Fresh order and possession may be given.
That had the order is in that terms only. That the authorized officer may communicate a date.
You
on which-
communicate a date so that it can be done. So I am disposing of the matters then. Unnecessarily keeping it pending will not serve any purpose.
Lordship, in one of the matters, we have already given the police cost. We have deposited it. And next, we will do the needful, your lordship.
This is in respect of which matter? This one?
Both the matters. Both the matters.
Fresh orders in both the matters?
Yes.
This takes care of both the properties?
Yes, my lord will kindly see the schedule of property heading in the first page. This contemplates both 1A and 1B. In the first page, my lord, schedule of property.
First page, schedule of property.
This 1A is 1 kotha 1 chitaks 27 square feet of land. And 1B is below
both
1 kotha
both
land.
the petitions can be disposed of on the basis of this order.
Same order, yes.
You have it in the form of affidavit, no?
In the affidavit, no, it was not also your lordship's pleasure to put it in affidavit, but yes, report was called for. Yes, the report is on the way. I have been told. The officer yesterday the order was passed. Today they have it comes from not 24 Parganas.
Just for the sake of compliance,
yes,
would have kept it on record.
We have been told that their officers are on way carrying the report. But,
very well. I am recording this. In any case, since this is there and it is not in dispute.
Not
Likhun.
been communicated with this.
This writ petition has been filed alleging arbitrary Has been done.
It has been done, yes.
Yes. লিখুন today when the matter
Grateful.
Because I did not want the direction of refunding of the money. That is very pricking to the economy.
Yes.
You have read Transcore.
Yes.
There is a line there. NPA is a cost to the economy of
Cost
the
to
nation.
economy. Yes.
It's important. We cannot sit on a stockpile of NPAs. The entire account, everything will go topsy-turvy. Merely because of somebody's inaction, everything will go haywire. Again, putting up the property for sale. No matter, nobody knows who will come forward. There will be an auction or not. Another round of challenge.
Everything gets clouded. And my lord, if your lordships are required to reiterate settled principles of law in
that
court,
becomes all.
that also takes away hours of court.
Yes, unnecessary judicial wastage. And all these days, I was giving time only because I was thinking that good sense will prevail. It's High Court's order.
Yes.
And not once, two, three, four, several orders are there.
Lord, my juniors tried their level best, then I did, then the GP also did. Ultimately, good sense prevailed over them.
Yes.
They understood.
Because see, in a fit case, this also amounts to contempt. It is not a specific order only. You have knowledge of the order and you are violating it. That amounts to contempt. Because it's High Court's order, it's binding on everybody.
Everybody.
And it's not today's order. It's more than 1 year now.
Grateful, your lordships.
Thank you.
Lordship, I am mentioning upon service, your lordship, for extension of
Change of hairstyle.
my for extension of interim order. My lord.
Extension of interim order. When is it going to expire? This month?
End of February. your lordship.
আস্তে আস্তে করে দিয়ে দেবে।
Deployment.
Lord, they were asked to say from their portal whether order has been passed or any progress has been done.
What is your instruction? Has it anything been done?
Lordship, we have wrote mail, but we have not received instruction.
Not today. I'm making it not today. Tomorrow it will appear again.
Instead of not today, kindly make it not this week, so that I expect them by tomorrow. I will even issue another mail to them.
Number.
I'm deeply afraid.
But that is Mr. Patiola online, my virtual.
Please, my lords. I'm sorry I couldn't travel today, my lords.
Not a problem. Where is Mr. Bhattacharya?
Lordship, he's in courtroom 10. Your lordship, I'm praying for a short Passover.
Let him start, my lord.
Prayer for a Passover.
He is making submissions.
Very well.
Let him come.
Who was called on? Nobody was there. Your other side was there. Chalo, next. Next call. Next.
Lordship, I am for the respondent number 8. We have not been served by the petition copy.
Yes, yes.
Respond number 8 আছে
respond number 8 আছে
certainly
আমরা সব কপি
respond number 8
Respond number 8. The copy has not been served. The bank, the bank
ये एफिडेविट ऑफ सर्विस है मेल पे सर्विस किया तभी पता है उसको.
Anyway, I am the answering respondent. So bank is there. We have attached the property from the bank, so they made the bank as a party. So actually, I have to reply him why I am entitled to attach the copy.
Yes.
I have served
So we have served the supplementary affidavit upon the Banerjee's juniors, I believe so. May I-
The supplementary reasoning. No, it's supplementary action.
The copy, may I- copy to us also.
Why is this supplementary required, Mr.?
Facts of the case, very short.
Subject matter of challenge in the writ petition is an action taken under section 226 subsection 3 by the assessing officer. Now, the assessing officer issued a notice covering at least 5 assessment years that these are the dues. With respect to which it is my submission, it is also on record, undisputed. Appeals were pending as on the date when the action was taken under section 226(3). The fact remains that, my lord, when the action was taken, obviously we registered objection. We came to know from the bank. We registered objection before the assessing officer in writing. The objection was both on merits and also on, my lord, jurisdictional issues. The objections were dealt with not on merits but on jurisdictional issue. And, my lord, the demand which was otherwise reflected in the notice under section 226(3) or the order under section 226(3), my lord, the assessing officer, while disposing of my objection, comes out with a different figure. Namely, why? Because, my lord, according to the perception of the assessing officer, if the appeals are pending, the maximum amount that can be asked for is 20%. He computed 20% and, my lord, raised the demand. Subsequent to the filing of this writ petition, what has happened, which is part of the supplementary affidavit, now, my lord, the TRO has assumed jurisdiction under section 222. It is my respectful submission before your lordship. Once TRO has assumed jurisdiction, having regard to the scheme of the act as provided for in section 222, read with section 226, my lord, any notice which had already been issued by assessing officer, my lord, would be, my lord, no longer enforceable, because TRO has been vested with the authority not only to initiate proceedings for recovery in terms of second schedule, but the TRO can also issue a notice under section 226(3). So this is one of my submission that after this initiation of the proceedings or the certificate being drawn up by the TRO under section 222, my lord, no proceedings under section 226(3) which had been initiated by the assessing officer can be continued. This is point A. Point B is that though the notice under section 226(3) was issued and a specific amount was spelled out or provided for, indicated in the said notice, covering 5 assessment years, while disposing of my objections, a different figure has been arrived at by the assessing officer having regard to the scheme of the act under section 220 subsection 6. If that be so, well, again, the first notice cannot survive. A fresh notice has to be drawn up, covering only that 20% of the demand, of the tax in demand. Fact also remains that, well, the total amount covering all these assessment years is to the tune of rupees 165 crores. Out of which, my lord, so far as 6.87 in excess of 6.87 or 6.75 crores was pending before the tribunal. Well, recently the learned tribunal has been pleased to allow the appeal of the assessee, preferred by the assessee. So, after filing of the writ petition. Secondly, my lord, there is another amount for 1 year which is to the tune of 83 lakhs or something like that. I will give your lordship the exact figures. There is a table. Well, that again, my lord, this is only penalty, and the quantum assessment, the quantum appeal has been allowed by the tribunal. So, my lord, once the quantum appeal has been allowed by the tribunal, my lord, penalty cannot survive. Now we come to an interesting part. The two years which we are concerned with are the assessment years 2019-2020 and 2020-2021. So far as assessment year 2019-2020 is concerned, my lord, where, my lord, the appeals were pending as on the date when they issued the 226(3) notices. Now the appeals have been rejected. Rejected, and, my lord, now we are in the process of preferring appeal before the tribunal. That period is not yet over, my lord. We can get the appeal ready and file it in due course. But, my lord, what is most important is that out of, my lord, 87 crores, 46 crores admittedly is the interest. For assessment year 9, 10, kindly take one page, my lord, kindly take volume 1. I will tell you, lordship, I'll give a lordship the clear picture of what is happening out there. Kindly take volume 1. The table is at paragraph, page 19, paragraph 16. I'll give your lordship a clear picture of what is now pending and what is to be done and what has been done thereafter.
Page 19.
19. Page 19. Yes, 18 and 19. Sorry. It starts at 18. That table.
Paragraph 16.
Paragraph 16. My lordship will find the figure. This is 165 crores 23 lakh 79,231. The assessment years are 5 in number, being 2015, 2016, 2017, 2018, 2019, 2020, 2020, 2021, and 23, 24. 1, 2, 3, 5. Okay. Now, Miller, kindly take the table now. For 2015, 2016, quantum appeal has been allowed. A. For 2017, 2018, we have paid 20%. After the read, we have paid the 20. Before the read, as a part of objection, we have paid. While we registered objection against the 226(3) proceedings, we also paid for the assessment year 2017, 2018, 20%. Now, Miller, kindly come to 2019, 2020. Miller has got that?
2019, 2020.
Out of this 87 crores, 9,17,161, I give a lordship the exact figure. My lord, 46 crores, 95 lakhs, 77,453 is the interest component. And, my lord, this is, your lordship will get it from page 343. That is, my lord, the computation. Well, that is in volume 3, volume 2. So, my lord, out of 83 lakhs, practically 47, for 83 crores, 47 crores go. So, we are left with a figure of around 40, no, not even 40, yes, 41 crores or something like that, or 40 crores. Now, my lord, we come to the next year, that is 2020, 2021. That is 70 crores, 50 lakhs, 47,890. My lord, when we registered our objection against the 226(3) order, we pointed out an addition of 32 crores has been made on account of the fact that certain transactions were entered into by and between my predecessor in interest, being an amalgamated company, and some third party, and which has not been, on which tax has not been duly paid. But I have documents to show that there was no such amalgamation at all. But that is on merit. But the merit was not addressed to by the assessing officer while disposing of my objection. I will tell your lordship, come to that directly. Now, when you come to the last year, that is 23-24, 6 crore 58 lakhs 49,542. Well, this has been totally deleted because of the recent order passed by the learned tribunal.
So this has gone.
This has gone. We are yet to receive the copy of the judgment, but the appeal has been allowed. That is my instruction. We have, in the supplementary affidavit, we have made that amendment on oath. So, this is where we stand. Now, kindly take the supplementary affidavit now, straight away. No, ask us. Kindly take the supplementary affidavit. Your lordship will now find, the 226(3) notices were issued on 8th of January 2026. We came to the court after 2 or 3 weeks because copies were not, the notices were not sent to us, though it was required to be sent to the assessee. So we got the copies from the bank finally. Similar, now kindly take page 11 of my supplementary affidavit.
Page 11.
Yes, my lord. Now, may I just take your lordship through this notice? I will come to the other notices later on. These to certify that a sum of rupees 165 crores 23 lakhs 79,231 has become due from you on 6th February 2026 in the status of company details which are on the reverse. You are hereby directed to pay the above sum within 15 days of the receipt of this notice, failing which the recovery shall be made in accordance with the provisions of 222 to section 232 of the Income Tax Act and the second schedule to the said act and the rules made thereunder. In addition to the aforesaid sums, you will also be liable for such interest is payable according to subsection 2 of section 220 and so and so, so and so. So, lordship will find this is the certificate. Now, my lord, so my lord, we get what we get, my lord, on 8th of January. Now, kindly, my lord, take the attachment notice, which your lordship will find at in volume 1 itself, page 170. Yes, only 70. Kindly take the attachment notice, my lord.
Page 70.
Yes. Your lordship will find this notice was issued on January 8, 2026. As on that date, the appeals for the assessment years AY 2019-2020 and 2020-2021 were pending before the CITA. For the assessment year 2019-2020, the CITA was displeased to reject our appeal on 23rd January 2026. That is subsequent to this notice being issued. And for the assessment year 2020-2021, CIT dismissed our appeal or rejected our appeal on 28 January 2026. And my lord, we registered our objection on January 22, 2026.
January 22, 2026 objection was against this 8th of January.
Yes.
Where is that objection?
Kindly take, my lord, 613. This will be volume, which volume? Now we get a continuous PDF, my lord. We get a continuous PDF, but your lordship doesn't get a continuous PDF. But I tell your lordship, my lord, Mr. Banerjee also does regularly matters before the Honorable Supreme Court. Now there is a continuous PDF system in Supreme Court. Volume 5. Kindly take, my lord, page 613.
What is this continuous PDF?
What is all the pleadings? All the pleadings are uploaded. Suppose there is a SLP. There are several counters. There are several rejoinders. Everything is uploaded by the AOR for the petitioner, SLP petitioner, and it becomes a continuous PDF in the soft format with continuing numbers. And when we prepare our notes, recently I prepared one notes. We had to give that PDF page number in our notes, so that the honorable
that
judge
can be immediately accessed.
Yes, immediately the honorable judge.
Can I hand over for a
I told you, lordship.
Just a matter, there was a 2-3 volume. If your lordship can you take it, lordship will
not.
Lordship will find that it's a continuous PDF.
So that all the folders are merged with.
number. But
So
this
when
practice,
we fall, then we point out and we go to the
yes, and this practice was first adopted by NGT. NGT used to do that because NGT introduced e-filing, I think 3 or 4 or 5 years ago, right? Now, my lord, now kindly take first, my lord, your lordship has seen the attachment notice. Kindly take my objection. Kindly take page 614.
614.
Yes, ma'am. Kindly take the first new paragraph at page 614. The assessee preferred an appeal under section 246A on 38/2025 against the impugned assessment order as above, which was uploaded with the acknowledged number so and so. The memorandum of appeal in form 35 along with detailed grounds and supporting documents is already on record. The appeal has a strong prima facie case and a fair chance of success owing to patent errors, incorrect assumptions and unjustified additions made on the basis of figures pertaining to other assessees. But this issue, while disposing of my objection, this issue was not dealt with. Because, my lord, it was my specific submission that this particular transaction with one particular entity, namely Sneha Garden, well, that was not a transaction with me at all. There was no such transaction and there was no amalgamation. Initially, when 148 ML, as an officer of the court, I must point out, initially when notice under 148A for this assessment year was issued, my lord, inadvertently or otherwise, a submission statement was made by the assessee. Yes, there was an amalgamation of some of the companies with the assessee company. Then, my lord, 154 application was made, rectification. The rectification has been now rejected, and now this is the upshot of the entire thing. Now, my lord, kindly take appeal and incorrect assumptions without due verification. Recovery of such disputed demand would cause grave and irreparable financial hardship to the assessee. Then we refer to the circular and then kindly come to the next last paragraph at page 614. The demand against us are disputed before first and second. First is NFSC and second ITAT appellate forum, where our appeals are lying pending for ages without any attempt to dispose of the same. We at our end have no control over the appellate authorities to get our appeals heard at an early date owing to high outstanding demand which is disputed. Such disputed demand also includes tax demanded on account of additions made on the basis of estimate as well as inclusion of erroneous figures relating to other assessees without application of any mind in the course of assessment proceedings. Despite such high-pitched assessments, admittedly for assessment year 2019-2020, it has been recorded in the appellate order that the demand is 143 times higher than the returned income, admittedly. So this is how it stands. Now kindly take the disposal of objection. How the objection has been disposed of. That is at page 615. But this is again happening on 24th January 2026. Well, even the assessing officer is not aware. At that point of time, nobody is made aware that so far as the appeal for the assessment year 2019-2020 was disposed of on 23rd January 2026.
And the adjustment is in respect of 2019-20?
Everything.
Inclusive of that.
Inclusive. Well, now the bank has, all the bank accounts have been attached, and one of the account is an escrow account which we have to maintain to comply with the provisions of the RERA. There are several accounts. Now, shop kora RERA. 5 accounts are RERA accounts, are 2 current accounts. So, now, so whatever amount is deposited, if we apply 226(3), obviously, my lord, the income tax authorities are at liberty, having regard to the position of law or the statutory provision contained in 226(3), they may appropriate. And this is not my money. This is the buyer's money, which goes into the escrow account. Kindly take now, my lord, page 615, how they dispose of. So first, my lord, neither made, I must read it out. In this connection with the above, please note that letters dated so and so were issued to the assessee for payment of outstanding demand, which were delivered to the assessee on 19 February, 11 June, and 7 July 2025, respectively. However, the assessee has neither made any payments nor responded to the aforesaid communication. The assessee was considered assessee in default. My lord, hence, the proceedings under section 226(3) of the Income Tax Act was initiated by taking prior approval of the learned PCI. For ready reference, the confirmation of delivering mails to ITBA system are as under. The mails were delivered. But I am not making this submission that the mails were not delivered. Then kindly come to 617. Thereafter, notice under section 226(3) of the Income Tax Act were served to the respective banks on 8 January 2026. However, copy of the order is enclosed for reference. So, this for the first time, the copy of the 226(3) order is being forwarded to the assessee. 3.1.3. Being aggrieved, the assessee has now filed an objection under a letter on 22nd January 2026. This records the fact that I registered my objection prior to the appellate order being passed for the assessment year 2019-2020. The contention in the said letter along with the rebuttal of the AO are as under. So, this is how the submissions are considered. Pending appeals before the CITA and ITAT, please refer to instruction number so and so. Now he falls back on the 20% formula. Well, the cut and dried method as provided for in the circulars. Now, if it is 20%, now the demand is restricted to, according to them, it is 18 crore 94 lakhs. Your lordship will find at the end of the table. Now, if that be so, the first 226(3) notice cannot survive. Practically, my lord, so far as that demand is concerned, they are conscious of the fact that when the appeals are pending before different fora, my lord, this recovery of the entire amount would not be permissible having regard to the provisions of the law content in the income tax. Which one? Oh, page 70 is the attachment notice. Obviously the jurisdictional assessing officer issued the attachment notice covering 165 crores. Now the JO also issues the
but to the extent of 20%, why would it not be permissible?
Then my lord, my case would be that
245.
No adjustment, nothing. This is not a case of 245 at all, man. This is a case where my bank account has been attached under 226(3). My lord, kindly may I take your lordship to 226. Kindly take the provision as such. But there is no adjustment against, my lord, the dues or the refund in this case. But it reinstates my case that it can never exceed 20% under no circumstance. And my lord, today, this 20% formula, my lord, I am proceeding, I am just my lord, inching a little further. This 20% formula may not be applicable in case of high-pitched assessments. These are high-pitched assessments, my lord, 70 crores. One is, my lord, addition is about 50, sorry, one is 70 crores, another is 87 crores. These are high-pitched assessments. My lord, the Honorable Supreme Court, my lord, Justice Nariman speaking for the bench, held that this 20% formula cannot be the, my lord, cannot be taken to be a formula which has to be adopted in every case. Now, my lord, kindly take 226(3). I will take your lordship to all that later on. Kindly take 226 as it stands now. First 222. My lord has got the text. Yes. When an assessee is in default or deemed to be in default, in making payment of tax, the tax recovery officer may draw up under his signature a statement in prescribed form specifying the amount of areas due from the assessee. Such statement being hereafter in this chapter and in the second schedule referred to as the certificate, and shall proceed to recover from such assessee the amount specified in the certificate by one or more modes mentioned below in accordance with the rules laid down in the second schedule. But there are 4 modes, that is attachment, sale, etc., etc. Attachment, sale of movable, then immovable, arrest, and finally receiver. And subsection 2, kindly, my lord, take. The tax recovery officer may take action under subsection 1, notwithstanding that proceedings for recovery of areas by any other mode have been taken. So, my lord, this is 222(1). Now, my lord, now kindly take 226. But where no, my lord has got 226, where no certificate has been drawn up under section 222, the assessing officer may recover the tax by any or one or more of the modes provided in this section. So when there is no certificate, the assessing officer has the jurisdiction to invoke the provisions contained in 226, subsection 2, 1A. Where a certificate has been drawn up under section 222, the tax recovery officer may, without prejudice to the other modes of without prejudice to the modes of recovery specified in that section, so 222, the modes of recovery, recover the tax by any one or more modes of provided in this section. So, my lord, the tax recovery officer is vested with the jurisdiction to initiate proceedings under section 226 once he issues a certificate in terms of, my lord, 222. That's a statement. Subsection 2. If any assessee is in receipt of any income chargeable under, this is not relevant. My lord, kindly take now 3. Your lordship will find now 3(i). The assessing officer or the tax recovery officer may at any time or from time to time by notice in writing require any person from whom money is due or may become due to the assessee, or any person holds or may subsequently hold money for on account of the assessee to pay to the assessing officer or tax recovery officer either forthwith upon the money becoming due or being held or at or within the time specified in the notice, not being before the money becomes due or is held, so much of the money as is sufficient to pay the amount due by the assessee in respect of areas or the whole of the money when it is equal to or less than that amount. Your lordship will find all these sub clauses of subsection 3 and also subsection 4(5) of section 226 refers to the uses tax recovery officer and assessing officer interchangeably. My reading of the provision is that when there is no certificate, the assessing officer has the jurisdiction, which the assessing officer had exercised. But in my most respectful submission, that assumption of jurisdiction was an improper exercise of jurisdiction, having regard to the facts that all my appeals were pending, and more so with respect to couple of assessment years, my lord, my stay petitions were also pending. Secondly, my lord, at the stage of recovering, at that stage when the appeals are pending, no certificate, no recovery could be, or no process for recovery could be initiated for any interest amount at all. Next, my lord, now part of the demand has been deleted, admittedly. In the event, the tax recovery officer, during the pendency of any notice or order, or the currency, I mean pendency, I must use the expression currency, during the currency or the operation of any notice or order under section 226(3), assumes jurisdiction under section 222(1) and issues a certificate, then it is only and only the TRO which is clothed with the authority to initiate proceedings under 226(3). So any notice issued by the assessing officer prior to the assumption of jurisdiction by the TRO with the issuance of certificate under section 222, my lord, must go, would be of no effect from the date of assumption. I am not making this submission before your lordship that the TRO is denuded of his power to issue a fresh 226(3) notice. That TRO has got under section 226(3). But that can only be done by TRO. TRO may initiate proceedings under 222 and also initiate proceedings under 226(3), and both the proceedings can operate on parallel scene, but not the assessing officer once the TRO assumes jurisdiction. Secondly, my lord, coming back to the assessing officer's, my lord, disposal of objections, that order, the recent one, the assessing officer has not addressed my application for withdrawal or revocation of the 226th order, 3 order on merit, when I have made submission, or I have made submissions on merit before the assessing officer. So, my lord, we are at my lord, this kind of stage that first there was an order under 226(3). The order had referred to an X amount. I register my objection. Once the objections are disposed of, now the assessing officer says it is not X, it is Y amount. Admittedly, these are not facts. Then, my lord, the TRO assumes jurisdiction, and with the assumption of jurisdiction of TRO, no further proceeding can be initiated by the assessing officer. My lord, everything should go to TRO. The TRO is at liberty to act in, obviously, to act in accordance with law. Obviously, we would have a right to challenge, because even TRO, if the period for preferring appeal is yet to expire, there are authorities to support my contention that the TRO, whether TRO can assume jurisdiction or not, is a matter of justiciable issue. But what we are on today is that with the TRO's assumption of jurisdiction and with a practically non-speaking order, having regard to the fact that the facts have not been, the merits of the my claim have not been addressed to by the assessing officer, JAO, the order dated January 8, 2026, would have to go, cannot stand. It cannot stand also for the reason that the objection, the order disposing of objections refers to an entirely different amount and practically falls back on the provisions and the circulars governing 220 subsection 6. That notice cannot, or that order of 8 January cannot survive. Would I take your lordship once again back to 3 or 4 documents? If your lordship,
I'll just come back to you. Mr.
Yes, certainly.
Just give me a moment.
Yeah. Oh, I will go.
By which letter do you say that the TRO has assumed jurisdiction?
It is in the supplementary affidavit. The certificate has now been drawn up. Page 11. Your lordship will find it refers to ITCP, the form, Rule 2 of second schedule. No, वो तो अलग आदमी है ना. Has to. That is TRO. Only TRO can do. Naturally, TRO can only do that. When TRO has done that.
And when were the attachments done?
Attachments were done, may I give you lordship the dates? 3 notices were issued demanding tax in 2025, which have been referred to in the order disposing of objection. The last notice was issued in the month of July 2025. There was no notice between July 2025 to 8 January 2026. On 8 January 2026, the AO, issues this 226.3 order. When the order is served, when we get the copy of the order, we register our objection on January 2022, 2026. On January 23, 2026, it so appears now that the CITA has disposed of the appeal, the NFAC has disposed of the appeal for the assessment year 1920. On 24th January, it was not even known to the assessing officer. I do not know, I'm not here to comment on that. On January 24, 2026,
he passes this order overruling your objection.
Rejecting my objections and accepting partly because the figure is entirely different now. So
the appeal was disposed of.
One appeal was disposed of.
It was disposed of by rejecting or by allowing?
No, rejecting.
So the demand stands.
Yes, I have annexed that order.
Demand stands.
Yes, demand stands. Now my remedy, so far as the appellate order is concerned, I have to go before the tribunal. But the period for preferring appeal, it is still there. I can prefer appeal within the statutory period, and it is still there. I will prefer appeal because that is the only remedy that I can take so far as the appellate order is concerned on merits. But my prayer, my submissions are limited. So far as the merits is concerned, is limited for the purpose of the order made under section 226.3, nothing more than that. I cannot make that submission because
right.
Now what happens on January 28, 2026, the appeal for the assessment year 2020-2021 was again dismissed. So there are 2 appeals, 2 periods, 2 high-pitched assessments where the appeal, the CIT has confirmed the order made assessment orders. These orders would have to be carried to the tribunal. There is no doubt about it. Now, my lord, this is 4th February 2026, the TRO, obviously on a reference from the assessment circle or whatever it may be, my lord, assumes jurisdiction and issues a certificate in terms of Rule 2, Red B 222(1) in form ITCP. Your lordship has got that. So, my lord, there are, as I pointed out, there are three limbs. One, appeals pending. Two, stays pending. My lord, 226(3) notice issued. Number two, objections not considered properly. Number three, it's a fresh demand. So far as the order disposing of objection, so it can only be by way of another 226(3). These two earlier 226(3) has to go. Then, my lord, finally, my lord, he is denuded of his power because of the assumption of jurisdiction. I mean, the assessing officer is denuded of his power to continue.
But the attachments of the accounts have been done prior to the issuance of this certificate.
Yes, absolutely. No doubt about that. The 8th January, but one is 8th January, one is, that is my submission is that, the legal submission is that once the TRO assumes jurisdiction, you cannot continue with the certificates issued, I mean, the assessing officer cannot continue with the certificate issued, I mean, the 226 order issued by him. Because now only TRO would have the power. Otherwise, my lord, it will be double whammy for
Prior
the
actions will also be annulled.
Sorry?
The prior action.
Prior actions, my lord, prior action.
Or will they merge?
No, may I just make this submission? It's not a question of annulment. It's not a question of merger. The prior actions would die when the TRO assumes jurisdiction. But the death of this prior action would not disable the TRO from initiating further action in terms of section 226(3) and all the subsections contained therein. And secondly, my lord, 8 January 2026, my lord, that action otherwise also cannot stand because, my lord, their order disposing of objection, it speaks of a different amount altogether. So it basically, my lord, abandonment of the notice dated or the order dated 8 January 2026 issued under 226(3). The assessing officer himself has made it clear in his order disposing of objections. Look, the demand cannot be 165, it can only be 18 point something, 18 or 19 crores. And my lord, 6 is now gone by, the 6 has been taken care of. No, 25 can also. 18 point plus 6, but 6 has not been knocked off because by the, in view of the order passed by the tribunal, we'll get the order, but I've made that positive averment in my supplementary affidavit. So, my lord, now my prayer would be before the lordship, having regard to the fact that the initial notice has basically been overridden by the subsequent order disposing of objection and also assumption of jurisdiction by the TRO, the initial notice dated or the order dated 8 January 2026, my lord, should be quashed. Obviously, my lord, the law will take its own course. If the TRO wants, TRO can do, and we will register objections in accordance with law before the TRO. क्या दिखाएंगे इधर? And so, my lord, and one more thing, my lord, so far as, my lord, 32 crores, but the addition of 32 crores for the assessment year 2021 is concerned, my lord, we have the order passed by the NCLT that the amalgamation is in no way connected with the assessee before your lordship. We have the order. You can't just hear. The lordship directs us, my lord, we will produce that order also and also share that order with my learned friend. This is an order passed by the NCLT. I understand that. No, 32 crores, not the other way. नहीं, GST उसका होता नहीं है. No, GST is not that. $32 crores is the addition of the tax. 50 crore उसमें addition नहीं था. 90 crores was the addition. 91 crores. Look. 91 crores is the addition for this. 91 crores is the tax. But this is again, my lord, something unique.
This,
Yes, my lord.
this 24 January 2026 letter, I mean the order disposing
Correct.
of your objection
Yes,
to the 226(3) proceedings,
right, my lord.
this 18 crore and odd, this is actually not the total demand. This
This
is
is not the
20%.
Yes,
This is
he-
20%.
He has
of the total
applied
demand.
the circular.
Yes. So the total demand which was mentioned in 8 January 2026 notice, how is that
Yes, madam.
overridden
May I
by-
just read out? Kindly take. I'm so grateful to your lordship. It has come from your lordship. Kindly take, my lord, 618.
618? Yes.
Yes. Further.
Oh, the one which is below.
Yes. Not only that, ma'am. Therefore, the demand payable as on date by the assessee stands at 25 crores. Madam, 6 crores goes because of, my lord, the order passed by the tribunal. রানা তার উঠতেই তো হচ্ছিস কেন?
Yes.
So, my lord, the demand gets modified. So it has to be a fresh notice. And now he cannot issue any fresh notice. It is for the TRO to take steps if the TRO is otherwise thinks of taking that.
Yes, Mr. Banerjee.
Yes.
Seems I do not have much thing to defend myself. But still, if your lordship kindly turns to section 1A of 220, I think the entire section 1A of 220. If your lordship
Zero.
can-
220 1A.
One. Lordship, probably the entire argument which is German is or demand was there, then the attachment was there, then they own a matter, so the demand will be reduced, so the jurisdiction will change. That is their basic submission, if we have understood it and followed it. So the first reply to this is whether a demand when issued will remain on variating fact they are so. That is the question we have to see today. That once a demand has been raised on someone, then whether that demand will remain in force or will not in force, that has to be seen on happening of certain events. What are those events? Appeal allowed, appeal disallowed, goes to the ITAT, goes to Supreme Court. On happening of this event, what is the strength of the demand which was initially issued? That has to be seen. That the reply we will get from 1A, and this amendment came only in 2014. If your lordship kindly see, may I read it for your lordship? Where any notice of demand has been served upon an assessee and any appeal on other proceedings, as the case may be, is filed or initiated in respect of an amount specified in the said notice of the demand, then such demand shall be deemed to be valid till disposal of the appeal by the last appellate authority or disposal of the proceedings as the case may be, and any such notice demand shall have the effect as specified in section 3 of taxation law, continuation and validity of recovery proceedings such and such. So lordship, today what the argument has been advanced, that one appeal they have won, so automatically it will drop down. Tomorrow I filed appeal because 2 appeal he lost before the CITA. So that will remain. Other one which he own in ITAT, that amount will fall and then it will go. No. 1A is very clear. 1A clearly says until we go, because 3rd February is the order, it may so happen that we come, the department may come before the court against that in 260A, and then we can get a stay order. So it's not, because since we are within the period, which my learned senior friend has argued in respect of CITA, the same chronology applies to me in case of ITAT. So this will be my first. And then the section 1A gives me the power to remain in strength with my attachment till the last. So my demand, this is my first reply to them, that the demand which will be, he said my demand will be fluctuating demand. No, my demand will remain same. Now, Lordship, what is the amount he has deposited so far? Lordship, if your Lordship kindly takes a note that yes. If your Lordship kindly looks into, the total demand was 1 crore 65 lakh. No,
165.
160. Sorry,
Not 1 crore.
mentally could not process it. I'm sorry. So 165 crore and 35 lakh was the demand. Then, Lordship, if we look into the actual facts and figures, Lordship, for the 2015-2016 assessment year, demand was 92 crore 60 lakh something. So, and the total payment he made is 19 lakh 83. Lordship, he has shown a chart. Petitioner chart. Petitioner chart. If your Lordship kindly see the chart which they have shown in the petition at page para 19, page 19, Lordship. This is para 16, page 19, bottom of page 18.
Yes.
Lordship, 2015-2016, they have shown 83.37.
Yes.
It should have been 92.60.730, according to my record. Against which he has deposited total payment 1983.156.
Where do I get that?
Lordship will not get that. This is my instruction I am saying to your Lordship.
No, but
payment.
Page 617, there is an indication of what was paid by the SSC. It shows 1923,390, 923,390. Page 617.
617. Yes.
The order disposing of the SSC's objection to 226.3. Begins at 615.
Actually, my lord, I don't want to, but just একটা ফিগারটা বলে দিচ্ছি just. না কত পেমেন্ট করেছে বলছি. What we have paid is, your lordship will find, though page 617 refers to a particular figure, but we replied thereafter, your lordship will find at page 619 we have paid 19 lakhs, sorry, কত? 19 lakhs 92,000 for 1 year and 5 lakh 42,000 for another year.
Yes.
Subject to correction.
Yes. 5,42,000 something.
They have indicated that you have paid 9 lakh or not in respect
No,
of that.
it's wrong. Something wrong happened, but that's not the correct.
No, Lordship, it's a typographical error. It should have been 1983, Lordship. That's what I'm admitting.
Typographical error of 10 lakh.
No, Lordship, is if you Lordship
It is not
kindly
only one.
One got deleted.
No, instead of 83, it is 23. So,
Now 23, malat 923 should be 1923.
oh, it's 19.
1923.
It is
That
1923.
means that one has
Similarly-
gone inside the line.
Yes. But for the other year,
If we subtract, Lordship, then it will show this, because my
Very well.
extreme right hand side column will show my intention.
it is about 26 lakhs or something like that. 25, 26.
Not 20. You
No,
have
total,
paid
total.
total is 25,662.
Correct. Right.
Total,
Absolutely.
total payment,
25,662.
Correct.
total
absolutely.
payment
Yes,
made by him
absolutely. Yes.
Absolutely.
for all the years.
For all the
No, not against all the years.
No, I'm
against the 15, 16, 16, 17. 17, 18, not for the other.
Now, Lordship, for 1920 to 23-24, no payment has been made. Admitted. Now, even if I give this credit of 19 and this 5, that do not counts to 20%.
No, but what is your answer to this? Your own demand has come down from 165 to somewhere around 25.
May I be given liberty to answer that question little late, Lordship? Because
Up to you. That is a troubling question.
Yes. because that will be the last question. If I can show from the entire record that the demand is this, 165 crores and odd was the demand, and he paid this, and I am saying 20% of that. That is all I am saying. In the whole procedure.
No, no. Your attachment is on the basis of 165 crore. You have attached
Yes.
on the
Yes.
basis of that. No, no, it's not that easy. Yes. So if your attachment would have got reduced to the tune of this much from 165 to 25, how can you
Lordship,
stick to your
that one
earlier order?
sentence, yes, Lordship, that one sentence maybe immediately I cannot justify because I have to take specific instruction on that sentence. I have not considered that while I was taking instruction. So far as this other part of this total raised demand, if your Lordship kindly see, if I compare this with 600, page 617 and page 19 of the writ petition.
Page 617 and page 19.
Page 19
No,
of the
no,
writ
the
petition.
page 19 is his pleading. We'll forget it for the moment.
That's what I'm
We are
saying.
comparing your own letter with your own order.
Yes, Lord. This one,
the
therefore,
letter
the
of
demand
attachment.
payable as on date by the SSC stands to this 25. This
Your attachment is proceeding on the basis of
165.
different figure.
165.
Yes.
Yes.
You have to justify that figure to continue the attachment, isn't
Yes.
it?
My lord, that figure, if your Lordship kindly see, that figure is clearly indicated in my page 106, 615, as well as if your Lordship kindly looks into
615.
Yes, Lordship. And Lordship, no, Lordship 615, which continues to 617.
Yes.
Pending, Lordship kindly see the total demand rest, column 3.3.
3.3, yes.
If you Lordship kindly see the total demand raised in the same letter,
yes.
In the same letter, Lordship will find that if we add this, Lordship, this will come to 165. So, Lordship, in the pending appeals, we have clearly indicated this is 165.
Then what is the reason for him saying that the
one sentence, Lordship. One sentence is probably either a typographical error or something. That clarification I have not obtained from my department. But so far, if we read a document, we have to read the document as a whole. It many times happens when we deny dispute, I do not admit, but typographical error not goes, then it becomes I do admit. So, Lordship, that is there, but I have to read the document as a whole. I cannot take a particular sentence from a document and say this has been modified or this. So, Lordship, if we clearly, categorically gives the picture against which is coming, Lordship, then the figure will exactly match with my figures. Now, Lordship, if your Lordship kindly see the fifth one. Now,
Mr. Mojumdar, this 25 crore and odd,
yes,
this is actually what is payable to you in terms of 20% is what he means to say. That is what I can gather.
May I just, I don't want to interject.
Yes.
It cannot
no,
be.
If I can make out of this because if
yes,
you see,
absolutely. That because 20%. But what has been done? Kindly take 618 once more. Page 618. It is not. It cannot be a typo. For the reason that at the end of the table, the total demand is 18 crores. Then he adds
20%.
Yes, total demand payable. He says.
Yes.
Sir, allow me 2 minutes. Then I
And
think
then
this
he adds
payable, and then within brackets 20%.
Then, my lord, no, very interesting. He takes 20% for all the years 7 except 23, 24.
Where he adds the entirety of
Where
it.
he adds, so it cannot be.
No, then kindly add this.
This is an order, my lord, disposing of my objection.
Lordship,
And
when I was
6 crores is
issuing
gone now,
this
my lord.
letter, Lordship, allow.
That's
When
right.
I was issuing this letter on 24th January, then the demand was there. Because he owned the IT-80 appeal in February 3rd. Oh, whatever, 3rd, 4th, whatever, in February. I was issuing this letter. So, Lordship, now you kindly see this 18, Lordship has seen this 18. and kindly see the next paragraph to it. Then Lordship will find such and such being such and such adjudicated the matter in a favor of the department and dismissed the appeal of the assessee. Therefore, the assessee is liable to pay the full demand of 658 for the assessment year 2023 and 2024. Lordship has got it. Now, if I assess this 4 plus this 6 point something, then it comes 25. That will be my explanation. So, under this order, the demand is of 20% because everything is pending on that day. While it is pending on the date of issuance of this letter, if everything is pending, then I am only entitled to 20%. And today, this will not be immediately modified because of I have shown 1A. Unless my
1A, the interpretation will not exactly be what you said. If the assessee has lost and the assessee has preferred appeal, then in that case, 1A will be interpreted in the manner you say. If the department has lost and the assessee has won the appeal and the demand has been struck off, still the demand will remain.
So, Lordship, that we have made this into two.
That can't be. Yes.
I So, Lordship, I have divided this into two parts. But on 24th January, this letter holds good. So, Lordship, we have to see this letter in a view of 24th January. Now, Lordship, kindly see, then 3.3 is one statement and the concluding statement is this. So, we have segregated. Now, Lordship, it is admitted fact by them that they have deposited this amount. The quantum of deposit is not under dispute. Quantum of demand is not under dispute. Then, Lordship, my proceeding initiated is not under dispute. Now, the only technicalities they are taking off that this amount could have not been done because of 26.3. Whether that will be allowed to them or not. Now, Lordship, if we now read once again 226.3. Yes, sir.
Yes.
Lordship, this assessing officer and tax recovery officer, TR. Lordship, it is used by or. Then at the time, at any time, may at any time or from time to time by the notice in writing require any person. So if we talk about any time, and if I accept the argument of my learned senior friend, then this any time should have not been gone with this. If it is zone specified, then it would have not been gone with any time. If we just look into two parts, like when there is a recovery prior to certificate, not in this case. I am taking an example from other cases where first certificate or the degree is issued and then the recovery starts. So the proceedings is completely different. When a certificate issues, then it goes to the certificate officer for recovery. Maybe under 1930 Act, maybe under 1993 DRT Act. When the certificate officer is there, certificate goes, decretal amount goes, and then recovery starts. So it is completely divided into two parts. The statute says, but here is a statute which says anytime and then interchangeably like or. So why? Because anytime a demand might looks like that it has come to an end. Like IT, it looks like it's come to an end. But it so may happen it might reopen. Because since there is a provision of traveling to the last forum, so anytime a someone will again may become a assessing officer, it demands back. So, Lordship, the interchangeably these two words is used and the expression is given is anytime. So, what my learned senior friends today argues that no, this has changed. So, again, you have to change the nomenclature. Probably in a fiscal statute, it is not possible. Because the flow of the money and the safeguard of the revenue interest also to be taken into account while we will interpreting these provisions. Because if we try to go in a way which always gives a time to rectify this, probably it is not. So, Lordship, usually a man is never apprehended under a criminal provision of law without due process of law or without a warrant. But when it's the matter of such seriousness, then a man can be apprehended not even by a police officer, but by a private arrest of few persons. Why these provisions are kept? Because certain areas, certain things are there to safeguard the justice, to safeguard the interest. If I say the private arrest is not possible, I have to wait till the police to come, he may fail. So, Lordship, here, if we really say that for a time it will be lifted off, and then, yes, same ban you can put it, after it is lifted off, you do a procedure, come back and then again. Lordship, probably in a revenue matter, that may not be possible. This will be my second limb of mine. So, Lordship, today, the demand is accepted, quantum of money is given, time and again we have informed him. Time and again we have informed him by notice that tell me your stage, whether there is a stay or not. Lordship, we have informed them thrice that they have also admitted. If your Lordship kindly looks into, we have informed them in the month of 1st February 2025, then June 2025, and then July 2025. And then in the notice, I put him to notice that if the assessee comply will be held as assessee in default and coercive measure as per the provision of the Income Tax Act for collection of the demand will be initiated. Every time I put him to notice, I said that I'm going to do coercive action against him. So, Lordship, when I was issued him, if he had any issues regarding my notice, February, June, July, he has not come. He has only come after the attachment order of 8-1. So he was just keeping an eye how the things is proceedings. And then he came to the court and saying these are the 3 technical issues. Save me from this attachment. Now, Lordship, the third point which my learned friend argued in the first place is REDA. Lordship, the accounts in the REDA under the new REDA law, Lordship, the accounts he has to maintain to show his solvency in case of failure of that. Because nowadays promoter takes money, they do not conclude the construction and they freeze. So now the new law says that the money has to put into escrow account for each project, inflow, outflow, so that they cannot utilize the fund for other things. It's his money, his profit is also there. So moment I stopped his all attachments so that he is not been able to do any, then he comes back. Lordship, we have to see this writ petition from all the perspectives. At what time he is knocking the door of the court, at what time he is. Now, Lordship, I will look into his objection he raised. Objection. Lordship, I will read the objection once more before you. The objection which they have given me is at page 613. My learned senior friend has shown that. जोड़ी दिए मैंने जी, खुलेगा तो छीनेगा कीजिए. Kindly see the date, Lordship, 26. In relation to the subject matter under reference, kind attention be placed on record our strong objection to initiation of this. By way of arrangement of the bank guarantee, bank account such and such without prior intimation, without disposal of our stay applications. And we humbly requested for immediate stay of the outstanding demand, which is disputed of various appellate courts. The assessment such and such was completed on such and such. Under such and such, read with this, the faceless assessment center New Delhi. The said assessment suffer various such and having been framed on the erroneous consideration, non-application of mind, resulting in highly lopsided determination of the income and demand. In order to rectify the apparent mistake on the record, the assessee filed rectification under such and such. Upon given effect to the said rectification, the assessee income consequently demand would be subsequently reduced. However, the said rectification application remains undisposed till the date of filing of the appeal. This case is presently pending before the National Faceless Settlement. Now, Lordship, kindly see, if we now look into, Lordship, kindly look into section 222. Lordship, 220 says that if a demand is not been paid,
Yes.
now Lordship provides, provided that where a result of such order under 154, 155, 154, 155, because he took the plea of 154. Provided that where a result of an order under section 154 or section 155 or section 250 or 254, 260, 262, order of the settlement sanctions, the amount on which interest was payable under this section had been reduced, the interest will be reduced accordingly in the excess of this to be this. Provided further, with the result of the order under a section specified in the first proviso, the amount on which interest was payable was reduced, and subsequently as a result of order under such and such, the amount on which the interest was payable under this section is to be assessed liable to pay interest such and such. Now I am going to 2A. Notwithstanding contain anything in section 2, the principal chief commissioner or this may reduce or waive the amount of interest paid or payable assessee under the subsection if he is satisfied that. Now, Lordship, kindly 3. A criteria has been defined there, under which criteria such could have been done. Why I am drawing your Lordship's attention here? Because unless I draw this Lordship's attention here, then Lordship, this letter, the objection which he gives, he has not made out any of those. So Lordship, today, now if we see, February 25 I issued him the first notice. Then June, then July. Then Lordship, he is putting his reply in the after almost a year, which is in January 26. And there he comes out with a case that these are my pending and I have not. I am not placing the circulars which says previously it was 15, then enhanced to 20. I am not bothering your Lordship with this. So Lordship, now reliance may be placed on Gujarat High Court in Harsh Deepak Shah case, where it has been held that in case of a high-pitched assessment, stay order under 226 would ordinarily be granted and recovery cannot be pursued merely by citing interest on remit. The Honorable High Court emphasized that the direction undertook must be exercised fairly, judiciously, and in accordance with law, such and such will be illusory. In a relation to the subject matter, under the reference, your kind attention may also be drawn that all on a sudden an amount in such and such has been brought to our knowledge that our bank account such and such Rajbihari has been attached against the disputed amount of tune of 165 crore 23 lakh 79,000 and odd. We lodge our strong protest against such unjustified illegal demand, principle of natural justice. The demand raised dispute such and such, then Lordship he goes to this. So Lordship, it was always a case known to all the parties that my demand is of 165 crores and all. So Lordship, today what he is saying, the demand against us are disputed before. I'm sorry.
Oh, your Lordship. Today there is a 3:30.
Yes. When can we have it next?
But
Tomorrow I'll be having a division bench.
I am told so, madam. Monday 3:30, madam. From
Monday we can have.
2 o'clock, I have a continuing matter. I will come and because I think Mr. My connected will continue for another 20-30 minutes. So I will come back and take it. Obviously, man, he's not going to spare me. I know that.
No, not really. So on my demand is only 20%. And I am dropping one item also. Item number 5, ITIT we are not demanding.
The order under section 220 subsection 6 has, well, 226(3) has preceded the order under 226. That's the case.
I will.
Your Lordship, may I kindly-
Just a minute, sir. Wait. Please wait.
3:30. কি বলবে?
সন্দীপ বাবু,
কি হয়েছে?
সোমবারে 3:30
একটা হার্ড কপি
আজকে বসছেন লর্ডশিপ ডিভিশন বেঞ্চ।
I'll be sitting tomorrow, but this matter, since it is a continuing matter, I'll break it again in between and I'll again have to hear it on Monday. So that would not have served the purpose. So I said so. If you are in difficulty on, tomorrow yours will be on Monday, not a problem. সোমবার করে দেবেন ওনারটাও।
Item 4.
আর এই এটা ফিলিপস যেটা আছে ওটা 17 তারিখ 17th করে।
Yours online, my lord. What is yours not?
Very good.
Lordship,
Yes.
permitted to mention one matter in Lordship's side. It runs in the serial number 3040. This matter has previously been mentioned at your Lordship's court on 30th of January. Your Lordship was pleased to upgrade the matter, but it has still not appeared on the list. Lordship, kindly
Item?
item 38 to 42.
What are these matters?
This
30.
pertains to a classification dispute as to what rate of GST will apply, whether 12% or 18%. We have also annexed the circular in which it is clearly stated that 12% GST will be applicable on AAC blocks with more than 50% of ashtray. Your Lordship, this matter has not yet been heard. Kindly, either Your Lordship and
What is the urgency that it has to be heard immediately?
the respondent authority will proceed with the proceedings. Your Lordship, I have been mentioned.
Let me finish some matters. I'll bring it up. I have consciously not brought it up because these are all adjourned motions. They have got a chance at least once. There are others who have not been heard even once. Please let them have a chance. I'll upgrade it.
Your Lordship, may I permit this matter was submitted before the Lordship, and Siddiqui has mentioned the matter also. Item number 762 of appellate side list.
Appellate side, nobody is there.
Your Lordship was pleased to allow the mention. I have mentioned it twice and twice your Lordship has said.
What has happened? It is not appearing.
It is not apparent. It has not been updated till now.
764 কি ছিল দিদি? Mr. Siddiqui, I remember he mentioned two matters. For one I said yes and for one I said no. That also I remember. So this is I think I said no.
That matter which your Lordship was pleased to allow the mentioning, my lord, that was supposed to be, but it has not been updated.
No, so I have asked it to be upgraded a little later. Let me
Because
finish some.
Registration has been suspended, they have not passed any order.
ওইটা আপগ্রেড করে দিন, যেটা হ্যাঁ বলেছিলাম তো।
63, 763.
আমার মনে পড়েছে, বললাম ওটা শুধু representation consider করার order.
Yes.
It will appear on Monday. Thank you.